Lord, 163. Lord, what was 1919 Act? Lord, I have quoted, but what is bold is, my Lord, relevant for the present purpose. For completeness, I have quoted this whole. 3. In relation to transferred subjects. My Lord, when the assembly talks about transferred subjects, it means subjects allotted to state. List 2, 7 schedule list 2, present. The entries may have changed, but transferred subject would mean the state list, where legislature has the power or competence to legislate. In relation to transferred subjects, the governor shall be guided by the advice of his ministers unless he sees sufficient cause to dissent from their opinion, in which case he may require action to be taken otherwise than in accordance with that advice, provided that rules may be made under the principal act or the temporary administration of a transferred subject where, in case of emergency, owing to a vacancy, there is no minister in charge of the subject by such authority and such manner as may be prescribed by the rules. Then kindly come to, my Lord, what was suggested, what was in 1935. My Lord, something similar, but please see 50 subsection 2. I'll read, my Lord, 1 also, because here the governor's discretion comes. Well, your lordships have seen yesterday, the president is not left with any discretion after 1919 Act till Article 111 as it stands today. I'm sorry, 75, which it stands today. 111 is a power of assent. But appointment is solely guided by the aid and advice of the Council of Ministers. In case of governor, my Lord, the situation was different. The discretion continued throughout, but the discretion came to be circumscribed by use of words which were very consciously used. Lord, please see Council of Ministers in 1935. There shall be a council of ministers to aid, counsel of, and advise the governor in the exercise of his functions, ministers except in so far as he is by or under this act required to exercise his functions or any of them in his discretion, provided that nothing in this subsection shall be constrained as preventing the governor from exercising his individual judgment in any case, whether whereby or under this act he is required to do so. The governor in his discretion, please see the Lord, may preside at the meeting of Council of Ministers if any question arises whether any matter is or is not a matter as respects which the governor is by or under this act required to act in his discretion or to exercise his individual judgment, the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion or ought not to have exercised his individual judgment. My Lord, kindly note here, my Lord, and park that contention, my Lord, for a subsequent thing. Two things. If he grants assent, can it be subject to the challenge? If he refuses to grant assent, both, my Lord, were immune from the judicial review. Now, draft constitution, my Lord, prepared by the constitutional advisor, Mr. Rao. There shall be a council of ministers with the prime minister at the head to aid and advise. Lord, even the provinces had prime minister. Lord, this, when we use prime minister, it was present day chief minister. There shall be council of ministers with the prime minister at the head to aid and advise the governor in exercise of his functions, except in so far as he is by or under this constitution required to exercise his functions or any of them in his discretion. If any question arises whether any matter is or so and so, my Lord, same, that should not be called in question. Now, my Lord, the draft prepared by the drafting committee. There shall be a council of ministers with the chief minister. Now, prime minister becomes the chief minister, my Lord. Only nomenclature changes, my Lord. Because there was no prime minister in 1935, the governor general was the whole and all, Lord, answerable to the crown. Chief minister at the head to aid and advise the governor in exercise of his functions, except in so far as he is by or under the constitution required to exercise his functions or any of them in his discretion. If any question arises whether any matter is or is not a matter as respect, my lord, same. Whether he exercises discretion rightly, wrongly, cannot be gone into. That is, my lord. Now I come to, my lord, the Constituent Assembly debate on this. And thereafter, my lord, the last debate I will read would be Article 200 and 201. Thereafter, my lord, the submission start, but your lordships must have, my lord, the background in which these provisions were drafted and formulated, the manner in which they were formulated, what was conceived. My lord H.V. Kamath. Mr. President, sir, I move that in clause 1 of Article 143, the words except in so far as he is by or under this constitution required to exercise his function or any of them in his discretion be deleted. My lord, Mr. H.V. Kamath has always supported the provincial supremacy over central supremacy. He was proponent of that. He may have some personal equations also, my lord, and he always used to object. But this was his, my lord, idea of the constitution. If this amendment was accepted,
influenced by the American system.
Highly influenced, my lord, by the Americans. Some of, my lord, that tendency and trait, my lord, continues even till date. We still believe in the American Constitution and apply it, my lord, in the context of Indian Constitution also. And that, my lord, sometimes results into laying down the law, my lord, which creates more complications than solving them. Sir, it appears from the reading of this clause that the Government of India Act 1935 has been copied more or less blindly without mature consideration. My lord, this is kind of a personal affront to Dr. Ambedkar, that you have copied something without applying your mind. There is no strong or valid reason for giving the governor more authority, either in his discretion or otherwise, vis-a-vis his ministers, than has been given to the president in relation to his ministers. If we turn to Article 61(1), we find it reads as follows: there shall be a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his function. When you, sir, raised a very important issue the other day, Dr. Ambedkar clarified that his clause by saying that the president is bound to accept the advice of his ministers in the exercise of all his functions. But here, Article 143 vests certain discretionary powers in the governor, and to me it seems that even as it was bad enough. But now, after having amended Article 131 regarding election of the governor and accepted nominated governors, it would be wrong in principle and contrary to the tenets and principles of constitutional government which you are going to build in this country. It would be wrong, I say, to vest governor with these additional powers, namely discretionary powers. I feel that no departure from the principle of constitutional government should be favored except for the reason of emergency, and these discretionary powers must be done away with. I hope this amendment of mine will commend itself to the House. I move, sir. Then, my lord, Mr. Krishnamachari, my lord, who generally echoes the views of Dr. Ambedkar, members of the drafting committee. And it was, my lord, by T.T. Krishnamachari, my lord. Your lordships are right. I'm grateful. Mr. President, I'm afraid I'll have to oppose the amendment moved by my honorable friend, Mr. Kamath, only for the reason that he has not understood the scope of the article clearly and his amendment arises out of misapprehension. He again gives it back, my lord, in a polite language. Sir, it is no doubt true that certain words from this article may be removed, namely those which refer to the exercise by the governor of his functions, where he has to use his discretion irrespective of the advice tendered by his ministers. Actually, I think this is more by way of a safeguard, because there are specific provisions in this draft constitution which occur subsequently, where the governor is empowered to act in his discretion irrespective of the advice tendered by his council of ministers. There are two ways of formulating the idea underlying it. One is to make a mention of this exception in this Article 143 and enumerating the specific power of the governor where he can exercise his discretion in the articles that occur subsequently, or to leave out any mention of this power here and only state it in the appropriate article. The former method has been followed. Here, the general proposition is stated that the governor has normally to act on the advice of the ministers, except in so far as the exercise of his discretion covered by those articles in the Constitution in which he is specifically empowered to act in his discretion. So long as there are articles occurring subsequently in the Constitution where he is asked to act in his discretion, which completely cover all cases of departure from the normal practice to which I see my honorable friend Mr. Kamath has no objection. I may refer to Article 188. I see no harm in the provision in this article being as it is. If it happens that this House decides that in all subsequent articles the discretionary power should not be there, as it may conceivably do, this particular provision will be of no use and will fall into desuetude. The point that my honorable friend is trying to make, while he concedes that the discretionary power of the governor can be given under Article 188, that is 200. No, I'm sorry, 356. My apologies. Emergency. One interesting thing, my lord, an unfortunate thing, when 356 was being drafted by the Constituent Assembly, Mr. Kamath again, my lord, objected to that central government cannot be conferred power. No, in the Constitution, when it was debated in the Constitution, he objected that central government should not have the power to impose precedence rule, and therefore Article 356 should not be there. To salvage the situation, my lord, it seems Dr. Ambedkar ji says very wisely that I hope and trust that this article would remain a dead letter in the Constitution. 3rd of November, your lordships are right. Your lordship remembers the dates also, my lord, correctly. I am grateful. Now, my lord, we are all students of law. My lord, unfortunately, in the first government which was formed after the first election under Pandit Nehruji, Lord, the first 356 use came in Kerala state. Nambudripad was the popular leader and he was unseated under Article 356. I'm not going into the politics of it. But that debate was going on, my lord, in the parliament, and debate was whether it should be exercised or not. And Mr. Kamath, my lord, made one comment which, my lord, I think he should have avoided. He said that when the Constitution was being debated in the Constituent Assembly, Dr. Ambedkar said that this article would remain a dead letter word in the Constitution. Today, Dr. Ambedkar is dead, but the constitutional provision remains and it is being operated. So possibly he had some personal, my lord, equations. But be that as it may, my lord, we are not concerned with it. Should be dislodged. No, he always, my lord, he was an absolute provincialist, that it should be completely immune from any central interference. All his, my lord, objections are leading to that provinces should be completely independent, and like American model. My lord, he was genuinely, maybe as a theory, ideas, my lord. And Mr. Kamath was a former ICS officer, resigned and started participating in freedom struggle, and he had contributed a lot, my lord, and he on his own right, my lord, elected to Lok Sabha. So he was not just a, my lord, troublemaker. He had a very strong view, and maybe some, my lord, we all have, my lord, likes and dislikes. I see no harm in the provisions in this article being as it is. If it happens that this House decides that in all the subsequent articles the discretionary power should not be there, as it may conceivably do, this particular provision will be of no use and will fall into desuetude. The point that my honorable friends is trying to, my lord, he ultimately says that let us wait till the actual conferment of powers in the respective spheres comes. Therefore, the serious objection of Mr. Kamath finds for mention of this exception is pointless. I therefore think that the article had better be passed without any amendment if it is necessary for the House either to limit the discretionary power of the governor or completely to do away with it. It could be done in the article that occurs subsequently, where specific mention is made, without which this power that is mentioned here cannot at all be exercised. That is the point I would like to draw the attention of the House to, and I think the article can better be passed as it is. Then Dr. P.S. Deshmukh, Mr. President, Mr. Krishnamachari has clarified the position with regard to this exception, which has been added to clause 1 of Article 143. If the governor is, in fact, going to have a discretionary power, then it is necessary that this clause, which Mr. Kamath seeks to omit, must remain. So first you decide whether he should have discretion or not. What discretion we will define when we deal with other articles. Sir, besides this, I do not know if the drafting committee has deliberately omitted or they are going to provide it at a later stage. And I would like to ask Dr. Ambedkar whether it is not necessary to provide for the governor to preside at the meeting. Malot, that may not be relevant. Malot, kindly turn the page over. Sri Alladi Krishnaswamy Iyer, sir, there is really no difference between those who oppose and those who approve the amendment. In the first place, the general principle is laid down in Article 143, namely the principle of ministerial responsibility that the governor in various spheres of executive activity should act on the advice of his ministers. Then the article goes on to provide, except insofar as he is by or under this constitution required to exercise his functions or any of them in his discretion, so long as there are articles in the constitution which enable the governor to act in his discretion and in certain circumstances it may be to override the cabinet or to refer to the president. This article as it is framed is perfectly in order. If later on the House comes to the conclusion that those articles which enable the governor to act in his discretion in specific cases should be deleted, it would be open to revise this article. But so long as there are later articles which permit the governor to act in his discretion and not on ministerial responsibility, the article is as drafted is perfectly in order. The only other question is whether first to make a provision, your options can skip. Now, please come to the bottom. Dr. Ambedkar, my lord, replies, Mr. President, sir, I did not think that it would have been necessary for me to speak and take part in this debate after what my friend Mr. T.T. Krishnamachari had said on this amendment of Mr. Kamath. But as my friend Pandit Kunzuru pointedly asked me the question and demanded a reply, I thought that out of courtesy, I should say a few words. Sir, the main and the crucial question is, should the governor have discretionary powers? It is that question which is the main and the principal question. After we come to some decision on this question, the other question whether the words used in the last part of clause 1 of Article 143, that is present 163, should be retained in that article or should be transferred somewhere else, could be usefully considered. The first thing, therefore, that I propose to do is to devote myself to this question, which, as I said, is the crucial question. It has been said in the course of the debate that the retention of discretionary power in the governor is contrary to responsible government in the provinces. It has also been said that retention of discretionary power in the governor smells of the Government of India Act 1935, which is the main was undemocratic. Now, speaking for myself, I have no doubt in my mind that retention on the vesting of governor with certain discretionary power is in no sense contrary to or in no sense a negation of responsible government. I do not wish to rake up the point because on this point I can very well satisfy the House by reference to provisions in the Constitution of Canada and Constitution of Australia. I do not think anybody in this House would dispute that the Canadian system of government is not fully responsible system of government, nor will anybody in this House challenge that Australian government is not a responsible form of government. Having said that, I would like to read section 55 of the Canadian Constitution. Article 55, where a bill passed by the House of Parliament is presented to the Governor General for the Queen's assent, he shall, according to his discretion and subject to provisions of this Act, either assent thereto in the Queen's name or withhold the Queen's assent or reserve the bill for signification of the Queen's pleasure. Three options. Pandit Hridaynath Kunzuru, may I ask Dr. Ambedkar, when the British North America Act was passed, Dr. B, this was kindly a sarcastic question, it seems. the Honorable Dr. Ambedkar, that does not matter at all. The date of the act does not matter. I mean, nearly a century ago. Dr. Mr. Kaman says that you are referring to.
Canadian Constitution must have been successor of the British North America Act.
Yes, which is 100 years ago. Therefore, he says that you are relying upon something which is 100
Relying
years.
on a provision which is a century old.
Century old, my lord, but without, while forgetting, I'm nothing turns on that a provision which has withstood the test of time for 100 years would not become invalid or not acceptable merely because of the vintage.
That's what Dr. Ambedkar deals in the next
Dr. Ambedkar says this. This is my reply. The Canadians and Australians have not found it necessary to delete this provision even at this stage. They are quite satisfied that the retention of this provision in Section 55 of the Canadian Act is fully compatible with responsible government. If they had felt that this provision was not compatible with responsible government, they have even today, as dominions, the fullest right to abrogate this provision. Dominions means dominions of the Commonwealth, my lord, under the sovereign. Dominions, the fullest right to abrogate this provision. They have not done so. Therefore, in my reply to Pandit Kunzuru, I can very well say that the Canadians and Australians do not think that such a provision is an infringement on the responsible government. Then Loknath Sharma, on a point of order, sir, are we going to have the status of Canada or Australia? Or are we going to have a federal republican constitution? Then Dr. Ambedkar, I could not follow what he said. If, as I hope, the House is satisfied that the existence of a provision vesting a certain amount of discretion in the governor is not incompatible or inconsistent with responsible government, there can be no dispute that the retention of this clause is desirable and, in my judgment, necessary. The only question that arises is, Pandit Kunzuru, well, Dr. Ambedkar has missed the point of the criticism altogether. The criticism is not that in Article 175 some powers might not be given to the governor. The criticism is against vesting the governor with certain discretionary powers of a great nature in the article under consideration. Dr. Ambedkar, I think he has misread the article. I'm sorry I do not have the draft constitution with me, except insofar as he is by or under this constitution. Those are the words. If the words were except whenever he thinks that he should exercise this power of discretion against the wishes, provides, does not leave it to the governor's sole discretion to decide where I will be exercising my discretion. That's, my lord, what Dr. Ambedkar. Otherwise, my lord, by aid and advice, which specifically reserve a policy of argument, will come further. That's what, my lord, it means. My lords are right. Now, next page. Therefore, as I said, having stated that there is nothing incompatible with the retention of the discretionary power in the governor in specified cases with the system of responsible government, the only question that arises is, how should we provide for the mention of this discretionary power? It seems to me that there are three ways by which this could be done. One way is to omit the words from Article 143, that is 163 today, as my honorable friend Pandit Kunzuru and other desire, and to add to such articles as 175 or 188, that is 200, and the emergency powers, or such other provisions which the House may hereafter introduce, vesting the governor with discretionary power, saying, notwithstanding Article 143, the governor shall have this or that power. The other way would be to say in Article 143 that except as provided in Articles so and so, specifically mention Article 175 or whatever they are. But the point I'm trying to submit to the House is that the House cannot escape from mentioning in some manner that the governor shall have discretion. Whether you put it under 163 or 200 later, that's not relevant. The principal question as a principle to be decided is whether governor should be given some discretion or not. And, my lord, thereafter 163 retains the discretion. Then, my lord, now the matter which seems to find some kind of favor with my honorable friend Pandit Kunzuru and those who have spoken in the same way is that the word should be omitted from here and should be transferred somewhere somewhere else, or that the specific article should be mentioned in Article 143. It seems to me that this is a mere method of drafting. There is no question of substance and no question of principle. I personally myself would be quite willing to amend the last portion of clause 1 of Article 143 if I knew at this stage what are the provisions that this Constituent Assembly proposes to make with regard to vesting of the governor with discretionary power. My difficulty is that we have not yet come either to Article 175 or 188, nor have we exhausted all possibilities of other provisions being made, vesting the governor with discretionary power. If I knew that, I would very readily agree to amend Article 143 and to mention the specific article, but that cannot be done now. Therefore, my submission is that no wrong could be done if the words as they stand in the Article 143 remains as they are. They are certainly not inconsistent. Conferment of discretion, how it operates, how it has operated.
It would have to be
My lord,
avoided.
I may make
Certainty and
one
clarity.
Lord, I may make one thing clear. While reading this debate, my lord, it is not my intention to argue and ultimately, my lord, raise a contention that governor has absolute discretion. That's not the purpose of reading this. The
You are
purpose of,
not-
my lord, by very nature of the article, it is so provided. And I'll, my lord, come to that. And when I read, my lord, Article 200 debates, my lord, that comes out because, my lord, there are, as my lord Justice Nasima rightly says, we understand the constitutional principles based upon how the function, how it has operated, how it has worked. My lord, there are some conventions which are also developed. For example, my lord, 163 says that the governor will act on the aid and advice of the Council of Ministers. Now, my lord, when the first person is to be called to form the government, there is no Council of Ministers. So the governor, by very nature of the act, will have to act on his discretion. My lord, when there is a dispute, which leader has the majority in the House? My lord, I must, my lord, tell your lordships and my lord, put a little word of caution for myself also. My lord, if we go by some example,
We are not going by that.
I understand. No, I am saying something else. Lord, Indian democracy is a mature democracy. There may be aberrations, my lord, on individual cases. But by and large, the democracy under this very constitution has worked very effectively. And that, my lord, I have personally witnessed, my lord, during COVID period. During COVID period, my lord, the Indian democracy and how the center province federal balance is envisaged what was at display. Lord, irrespective of the party in power in the center, which was Lord NDA, BJP, etc., all state governments ruled by Congress, ruled by communist, everyone, they were on the same page with the Honorable Prime Minister. There was no dispute, difference, and they used to call each other. That's the way democracy works. That you have debate, you have deliberation, you have consultation, you give suggestions, you take suggestions, and everyone was on the same page. My lord, since I was appearing, my lords, I know it for sure that chief ministers of those states whose chief ministers were very critical, and it was their right to be critical of the center. My lord, they used to call the prime minister at 2 o'clock that this is what we are needing, and there would be a serious problem, and the thing would reach. And my lord, the counter thing also. The government also responded in a matured way, except, my lord, one or two exceptional states. But everyone, my lord, because all these people, my lord, irrespective of the political leanings, they have, my lord, political experience of 30, 40, 50 years. They have that political maturity, my lord, to decide. So, my lord, it would be really hazardous, my lord, to even examine constitutional interpretation based on certain aberrations. There are ambitions, there are, my lord, pitfalls, but that is to be taken care of on a case-to-case basis. One cannot interpret the constitution based on the worst example because, Lord, hard cases always results into laying down of bad laws. That's, my lord, that's a settled principle throughout all jurisdictions. Then Dr. Ambedkar. Of course, there is, because we do not want to waste the precedent with any discretionary power, because the provincial governments are required to work in subordination to the central government. And therefore, in order to see that they do act in subordination to the central government, the governor will reserve certain things in order to give the president the opportunity to see that the rules under which the provincial governments are supposed to act according to the constitution or in subordination to the central government are observed. Please mark this, my lord. This is, my lord, the fundamental foundation of, my lord, the Constituent Assembly. And this is what was the thought, the principle of constitutionalism in the mind of Dr. Ambedkar, that they must be free to take decision, but there must be some level of, Lord, deference to the central government, because we have a quasi-federal constitution. Then H.V. Kamath, will it not be better to specify certain articles in the constitution with, my lord, he continues, my lord, with his objection, my lord. I may skip that. Now, my lord, kindly come to present, my lord. Green is article 163, which is at present. That normally, I'm paraphrasing, the governor will act in accordance with the aid and advice of the Council of Ministers, and governor must do it. We are not arguing A versus B. I'm assisting the court because we are seeking your lordship's opinion. So I'm just giving what is my reading of the constitution. Governor will have to act on the aid and advice except where he is having discretion, either conferred by the constitutional provisions or by the very nature of the power which he is exercising.